7 miles off the coast of Suffolk, in the North Sea, there is a steel and concrete platform sitting on 2 hollow concrete legs. It is roughly 4,000 square feet of usable surface, about the size of 2 tennis courts. It has a flag. It has a currency. It has a passport. Since 1967, the family that lives on it has called it the Principality of Sealand. The platform is not an oil rig. It was built as a sea fort during the Second World War. In 1942, the British Admiralty sank a barge in the Thames estuary, on top of which sat a pre-built concrete and steel deck supporting 2 anti-aircraft guns. It was given the name HM Fort Ruffs. After the Ruffs Tower sandbank it was placed near. 3 sister forts were built and placed in similar locations. The Maunsell Sea Forts, named for their designer, Guy Maunsell. They were Royal Navy posts. They held crews of around 150 men. They engaged German aircraft, German E-boats, and a small number of V-1 flying bombs in the Thames approaches. The forts were decommissioned after the war. Most were dismantled. HM Fort Ruffs was not. It was sitting outside the United Kingdom's territorial waters, at the time, 3 nautical miles, and the Admiralty appears to have regarded it as not worth the cost of removal. It was left in place. By the early 1960s, it was empty. In the mid-1960s, the United Kingdom had a wave of unlicensed radio stations broadcasting from ships and from abandoned sea forts in the Thames estuary. They were collectively called pirate radio. They played pop music that the BBC at the time did not. They were widely listened to and entirely outside the British broadcasting framework. One of the operators was a former British Army major named Paddy Roy Bates. He took over an abandoned Maunsell fort, Fort Knockjohn, and ran a station called Radio Essex. In 1967, the United Kingdom passed the Marine Broadcasting Offences Act. The act made it illegal for British subjects to operate unlicensed radio from any structure within UK territorial waters, and it ended pirate radio almost overnight. Bates wanted to keep broadcasting, so he relocated. On the 2nd of September 1967, he took his family to HM Fort Ruffs, which sat just outside the 3-mile limit. He did not start broadcasting. He declared the platform a sovereign principality and named himself its prince. A year later, the United Kingdom decided to test the situation. There was a confrontation at the platform. A weapon was discharged in the direction of a Royal Navy buoy tender. Accounts vary about exactly what happened, and Bates and his son Michael were brought up on firearms charges. The case went to the Crown Court at Chelmsford in 1968. The judge ruled that because the incident had taken place outside British territorial waters, an English court did not have jurisdiction. He dismissed the firearms charges. The Bates family interpreted the ruling as international recognition. Legal scholars, then and now, generally do not. The ruling addressed jurisdiction, not sovereignty, but it was the closest a court of any major nation has come to acknowledging Sealand as something other than a UK structure. In August 1978, Bates was off the platform negotiating a business arrangement on the mainland. A small group of men associated with a German businessman named Alexander Eichenbach, who had been involved in a passport and investment scheme run from Sealand, arrived by helicopter, took control of the platform, and held Bates's son Michael hostage for several days. Bates returned with a small armed party, retook the platform, and took the attackers prisoner. He released most of them but held Eichenbach, who had a German passport but had also previously accepted a Sealand passport which Bates considered Sealand citizenship. The German government sent a diplomat to negotiate Eichenbach's release. A German diplomat travelled to Sealand and negotiated. Bates released Eichenbach. The Bates family interpreted the German government's act of sending a diplomat as a second piece of de facto recognition. The German government has never said the same. In 1987, the United Kingdom extended its territorial waters from 3 nautical miles to 12. Under that change, the seabed under HM Fort Ruffs, and therefore, by most readings of the law of the sea, the platform itself sits inside UK territorial waters. The United Kingdom has not, since 1987, attempted to assert sovereignty over the structure. It has not removed the family. It has not contested the platform's flag. It has, in the words of one legal commentator, simply declined to engage. Sealand operates today, in practical terms, exactly as it did before the territorial waters change. What is missing is any formal recognition by any sovereign state. Roy Bates died in 2012. His son Prince Michael continues to administer Sealand with his own son Prince James in line. The platform is occupied. The flag is flown. A small number of people physically live there at any given time. Sealand sells titles online, Lord, Lady, Baron, Count, at low prices, primarily as novelty gifts. It sells Sealand passports, though after a forgery scandal in the late 1990s, the Bates family ceased issuing new ones. It has hosted, at various points, a data haven business and a national football team. It has a Wikipedia entry that runs to thousands of words. What it does not have is any recognition by any UN member state. Sealand is roughly 4,000 square feet of metal and concrete sitting on 2 legs in the North Sea. A family lives on it. A flag flies on it. A court once dismissed a case because it could not extend its jurisdiction to it. It is not a country in the way that the United Kingdom is a country. It is also, demonstrably, not nothing. It is a real platform. The family is a real family. The court ruling is a real ruling. The reason Sealand is interesting is not the question of whether it is a country. The reason it is interesting is the precise list of things it is and the precise list of things it is not, and how short the gap is between them.